imagine a father is rich, famous, and capable of providing everything his child needs. Yet, a Nigerian court refuses to grant him custody of that child. And yes, Nigerian courts do not grant custody based on wealth, nor does it grant custody based on self-recognition. Now, the story behind Davido and his child's mother regarding the custody of Imade, his child, has made a lot of people ask questions as to who gets custody when parents are separated. That's who gets custody of the child or the children of the marriage when the parents are either separated or divorced. Now, in today's video, we're going to be talking about what the court considers in granting custody, what the Matrimonial Causes Act says, and why most fathers lose custody cases even when they are financially capable of taking care of the child. Don't go away, we'll be right back. Now, by virtue of section 69 to 72 of the Matrimonial Causes Act, the Act provides that upon an application for the custody of a child or children of the marriage, the court should consider the welfare and the best interest of the child. Now, a judge who is faced with this application will be asking, where will this child grow better? Physically, emotionally, morally, and educationally? These are the questions that will be going through the mind of the judge who is going to grant this application for custody of the child or children of the marriage, especially upon separation or divorce of both parents. In order for the judge to make an informed decision regarding the welfare of the child and the best interest of the child, there are certain factors that the judge will look at to make an informed decision. One of them is the age of the child. If that child is between the ages of 0 to 10 years, the court grants custody of that child to the mother. Why? Because the child is of tender age and will require certain care and attention that a mother alone can give at that age. So usually the court grants custody of the child to the mother. Another thing the court looks at is the sex of the child. If that child is a girl child, the likelihood that the mother gets custody is very high, except the other party can prove that the granting custody to the mother would either endanger her life or affect her morally and otherwise. But in most cases, the court grants custody of a girl child to the mother. Furthermore, the court also considers emotional bonding. This refers to who has been caring for this child, who has been feeding this child, who has been bathing this child, who has been providing for this child before now, and who has actually been taking care of this child, who this child has bonded with. The court would consider that because it won't be very easy for that child to disconnect from who he or she had bonded with just because an application for custody was made, except the child chooses to go the other way. Otherwise, the court will consider who has been taking care of this child to grant custody to that person who has been taking care of the child. And then the court also considers the moral conduct. I mean, where this child is going to stay, will it be violent free? Would there be people who actually are involved in substance abuse in that environment? Will it be unsafe in terms of relationship? And would the child be neglected in that environment, the new environment the child will be going to? The court will consider where this child will be staying. Will the child suffer neglect? Will the child be exposed to substance abuse, or any form of abuse, especially when we're talking about a girl child here? Will the child be exposed to any form of abuse? Is the environment naturally safe, ordinarily safe for that child to stay in? The child will also consider that. And I mean, the court will also consider that. Now, the court considers the stability of the home where the child will now grow. If the child is going to grow in a stable home, the court will be looking at a stable home where the child can grow mentally, well, emotionally well, and psychologically well. So in doing that, the court will look at if that home is a troubled home. Of course, the court will not grant custody to that parent that is asking for the custody of that child. And then the court will also look at where the child will be given proper attention. I don't mean nanny attention, you know. There's a difference between a child who is raised by a nanny and a child who is actively raised by a present parent. So the court will look at where the child will be given proper attention by his or her parents. You know, the court will also look at where the child will get proper education. And it's not just in good school, but even the environment, is it suitable with people who are looking out for the child. The court will consider that school environment, discipline, guidance. The court will consider where the child will get the best of this. Now, the court will also consider the health and the safety of the child in terms of medical care and psychological well-being. The court will consider that, not where the child will be, and every time the child is curses are being rained on the child, you know, that is a form of psychological abuse on the child. The court will make sure that the the child is staying in an environment that he or she will get proper medical care and and good psychological attention in terms of a safe place generally. So these are the factors that would actually inform the mind of the judge in considering the best interest and the welfare of the child. Remember, I said that for custody to be granted to the parent of the child, it is the child's best interest that is being considered, not the wealth of the parents or the exposure of the. Now, in most cases, why Nigerian fathers actually lose custody battles in terms of the custody of their children is because the tender years doctrine is usually applied. That this is what I said earlier, that when a child is of tender years, the child is placed in the custody of the mother, where the child is actually taken care of, you know, and given proper attention by the mother, except the mother is proven to be unfit for that purpose. And in proving that the mother is unfit, probably you are going to be looking at maybe the character of the mom, or you're going to be looking at the mental state of the mom. What, in whichever way one wants to prove the unfit nature of the mom, it should come with a substantial evidence. Now, generally, when a parent is denied custody, that parent does not totally lose access to the child. Of course, the court has no right to prevent a parent from having access to their child or to their children. What that parent is usually given is visiting rights. The parent is given access in terms of visiting rights. The parent can go on holiday with the child or the children. The parents should get involved. They have a right to get involved in the schooling of the child. The parent also has a right to pay maintenance by Section 70 of the Matrimonial Causes Act. The parents should pay maintenance for the child. So the court has no right whatsoever to deny a parent total access. So people that tell you that they apply for total custody, no, the court cannot give any parent, cannot restrict any parent from having access to the child. Now, this brings me down to my advice to every parent that wants to apply for the custody of their children, especially the fathers. Make sure that you present your case, especially use a very good lawyer. I heard that in Davido's case, the counsel on the other side brought up the issue of what actually led to the death of his son, Ifeanyi, God rest his soul. As painful as that may sound, that step can actually, or the questions in that regard can actually tell on the mind of the court to deny custody to David Adeleke in this instance. Because remember, I said that the child must grow in a safe environment. So if the court sees that a child died in under your care, the likelihood of you losing custody over the next child is very wide. I mean, so when fathers are approaching the courts with custody applications or custody claims, they have to come correct. Like, use a very sound family lawyer and present your case, proving that if that child is given to you to take care of, that child will not just grow in a safe environment, but will grow emotionally, morally, educationally, and physically well under your care. I hope this helps. Thank you very much for having me, and enjoy the rest of your day.